My name is Catherine Carlton. I'm Executive Director of Orchestras Canada, Orchestres Canada, and I'm very pleased to be speaking to you today from our headquarters, at least my home headquarters, here in Peterborough, Ontario, long known as Nogajiwanong. This is the traditional territory of the Mississauga Anishinaabe people, covered by the Robinson Treaty, Treaty 20, and we honor the longtime stewards of this land, and we respect their teachings. Thank you. So on to the topic for today's session. The Ontario Not-for-Profit Corporations Act was proclaimed at long last on October 19th, 2021. This legislation was well over 10 years in the process, and it is the enabling corporate legal framework for most not-for-profit organizations incorporated in Ontario. According to a survey that Orchestras Canada did a few years ago, most of our Ontario member orchestras are provincially incorporated, so it affects many of you. And it's important to be paying attention as the new legislation may affect you in some important ways, including the requirement to get an audit, members' rights to make proposals and call members' meetings, and the number of your directors. Nonprofits will have 3 years after proclamation to transition to the new rules, and the clock is now officially ticking. So we're so excited to learn together today from today's expert guest, Benjamin Miller. Benjamin is a staff lawyer on the Nonprofit Law Ontario project of Community Legal Education Ontario, where he focuses on nonprofit and charity law and policy. Over the last 4 years at CLEO, Benjamin has answered hundreds of nonprofit law questions, and he's developed an online interactive bylaw builder for the ONCA. He also works for the Ontario Nonprofit Network, and he's also, as well, worked at the Canada Revenue Agency in the past. He holds both a Juris Doctor and a Master's in Public Policy from the University of Toronto, and a Master's degree in Political Theory from the University of Toronto. So I'll hand the talking stick over to Lauren Drew for some tech advice, and then we get to learn from Benjamin. Thank you so much, everyone.
Thanks, Catherine. I'm also pleased to be joining from Nogajiwanong, Peterborough. Very grateful to have grown up on these lands and had the stewardship of many First Peoples as part of my life and my growing up. So some tech notes: please keep your video and audio muted unless you are asking a question. If you would like to ask a question, please either use the chat function or raise your hand on Zoom and we'll call upon you. But otherwise, please keep your video audio muted to reduce background noise. A heads up that we are recording the session to put on our YouTube channel, and we'll share that recording with you in a few days after. There will be Q&A portions after each section of the presentation. So again, use the chat or raise your hand to be called on. We're offering English closed captioning from rev.com. So I will paste some instructions in the chat to enable that in just a second. And again, we are recording. We'll share the resources, including the PowerPoint, with you after the session. So with that, I will hand it over to Benjamin.
Thank you so much. It's a pleasure to be here. I'm always heartened when people take an interest in this legislation because, as I hope to make the case to you today, can be a great thing for your organization. Not only the legislation itself, but the process of coming into compliance with it. So over the course of the next hour, this presentation will have sort of 3 components. One, I'll discuss some of the new elements of the legislation. 2, I'll discuss what steps nonprofits may actually need to take if they want to get into compliance with the Act. And 3, I'll give you a brief tour of our website, CLEO's website, and some of the resources on it that you can use to help you get into compliance with the Act. So just a bit of background on the organization I work for, so you know where all this is coming from. CLEO is a legal clinic, part of Ontario's legal aid system, but as opposed to other legal clinics that do kind of one-on-one work with organizations, CLEO specializes in plain language and clear design information education products. So one of the questions that we got in the registration survey was, where can we find plain English resources? So I've got good news for you. This is the place. And the website I will show you at the end of this presentation has a great deal of plain language edited legal resources. If you're looking for other legal information, such as housing, employment, discrimination, you name it, many other things that may affect your orchestras, CLEO has information online on the stepstojustice.ca website. So a bit of housekeeping. So there'll be time at the end of each presentation to field some questions, but especially if there's a clarifying question, if there's some word you didn't understand, please feel free to ask it at the time you have it, either in the chat or by raising your hand. Because it's very important. The information builds on the previous information. So if there's confusion, you're probably not the only person, and we should deal with it immediately. A few disclaimers, because I am indeed a lawyer, and therefore we need disclaimers more for my benefit than anyone else's. Firstly, this presentation is general legal information. It is not legal advice specific to your situation. There may be variables I don't know about. Secondly, this is only a high-level overview of the ONCA. It's not comprehensive. That's what the website's for and other resources. And it doesn't deal with other areas of law that may affect you, such as charity law, although I will touch upon some aspects of charity law for the purposes of transitioning to the ONCA. This is about law and not best practices. As I like to say, just because something is legal doesn't mean it's a good idea. I'm highlighting what options are available to you under the law. It doesn't mean you need to or should take advantage of those new options. You have to figure out what's right for your organization. And lastly, this is about law and not about the expectations of your funders. Particularly in the area of financial review, there's new flexibility, but the funders haven't necessarily changed their expectations yet. So you have to be mindful of asking what is expected from your funders as well, which I will not talk about. So I would also like to acknowledge the land, both personally and as a representative of CLEO. And also use that opportunity to set some of the bigger picture of what good governance really means for an organization and for communities. So we, that is CLEO and myself, acknowledge that since time immemorial, the land on which we live and work, and in my case, that means downtown Toronto, has been the home and traditional territory of Indigenous peoples, including the Mississaugas of the Credit, the Haudenosaunee, and the Wendat, and is now home to many diverse First Nations, Inuit, and Métis relatives. CLEO's work is also carried out across the many traditional territories of this land that is also known as Ontario. We acknowledge that our privilege, as well as our role in systems of colonization. And in my case, that means that the corporate law makes certain assumptions about best practices and what counts as accountability. And that often may displace traditional or alternative forms of governance. So if you're exploring, how can you be more accountable to your communities? How can you engage better with the First Peoples in your location, and you're feeling there is tensions with the corporate law, then those are questions that I'd be happy to field and explore and highlight the flexibilities with you. But there are indeed those tensions. So CLEO staff are learning to be better allies by participating in training about the systemic nature of anti-Indigenous racism in Canada, and we're strengthening ties to Indigenous serving organizations in order to produce information and resources that reflect the experience of Indigenous peoples and develop training that is more relevant for and accessible to Indigenous peoples. So with that, I want to briefly highlight the differences between two sets of treaties that govern where I am. On the one hand, there's the Dish with One Spoon Treaty, which has been in place for hundreds of years between the Anishinaabe and Haudenosaunee peoples, and it's pictured an example of the kind of way it would be embodied, which is through a wampum belt, as pictured on the left. So these are intricately woven belts. And the way these treaties would be, and still are, manifested in practice is that at important meetings, a messenger would come and the belt would speak through the messenger, and the messenger would reiterate the terms and the history of those relationships between the peoples present at the meeting. Okay, so that's one kind of ideal of governance. Now contrast that with Treaty 13, the so-called Toronto Purchase, the first attempt at which happened in 1787. Now, the colonial authorities were so perturbed, they were so disturbed by its questionable legality that in 1805, they went looking for the document. And they only found one copy of it in a shed somewhere, basically, that was a blank deed with signatures from other pieces of paper attached to that piece of paper. So there are a few differences I want to highlight here that cut to the core in my mind of what does it mean to respect the teachings of the stewards of this land. The wampum belt reminds us that governance and legal compliance is not just something you write down. You don't just write down the rules on a piece of paper, file it away, and then not worry about it for another 20 years. Right? It's something that has to be reiterated and restored on a regular basis. And fundamentally, it's about relationships between people. So unfortunately, I often do come across organizations who more fall into the Treaty 13 bucket, where they wrote down the rules, they don't necessarily follow them or know what they are. They've stored it away, don't know where the document is. So the first message I want to leave with everyone here is that this presentation is about updating documents, but that is never enough to comply with the ONCA. It's once you've updated the documents, what are you doing in practice on an ongoing basis? So before we jump in to the substance of the presentation, there are a few key terms that I want to make sure we're all clear about. The first one is ONCA. The Ontario Not-for-Profit Corporations Act that we're here to discuss. So what is it? It's the legislation that most nonprofits incorporated under provincial law will need to follow, as Catherine mentioned. So specifically, it replaces Ontario's Corporations Act. So if you're an organization incorporated under Ontario's Corporations Act, ONCA is now the act that governs you. If you are incorporated under a special statute, it is very likely ONCA is the statute that governs you. If you're incorporated under Canada Not-for-Profit Corporations Act, this is not relevant for you and you can log out. If you're a cooperative corporation, if you're not incorporated, the act doesn't apply to you unless you're interested in incorporated under this act. The second term I'll highlight is letters patent. This is the document that the government sent you when you first incorporated. It says important things like your purposes, your address, the names of your directors, your founding directors, and it's now called articles. So it's just a bit of change in terminology in the new act. So this is one of the documents that you may need to make changes to come into compliance with the ONCA. When I talk about those changes, I may use the term articles. I may sometimes use letters patent, but I'm talking about these things interchangeably. Finally, and this is absolutely crucial, and I very frequently run into people who are unclear about this term, the word member. Nonprofits use the word member to refer to all kinds of things. You might have the member of the orchestra, the member of the board of directors, the member who's just a regular donor. They use it for all kinds of things, and that's all fine, and organizations are free to use the word however they like. However, for our purposes and for the purposes of corporate law, member has a more specific meaning. It's the people who are defined in your governing documents. So previously your bylaws, but under ONCA, it will be articles, who have the power to elect the board, to receive financial statements, to access important governing documents, to appoint the auditor. They have that kind of power. You can also have members who are non-voting members, but they will be set out as a group in the governing documents, in the bylaws. So when we talk about members today, that's who we're talking about, the people who are defined in the bylaws as having this important governance role. Okay, so there are many reasons that you may be here today, and indeed, we asked that in the registration question. Some of you are excited, some of you just know it needs to get done, some of you are a bit anxious. So let me share with you what I think it's worth caring about the ONCA, some different reasons. So number one, this is an opportunity to revisit your governance. Beyond what the ONCA requires, it's an occasion for you to take out all your governing documents, see what's actually in them, and see if it still makes sense for you. How often do you get to do that? Now's the moment to do that because you kind of need to in some cases for the ONCA. Number two, some new things are possible under the ONCA that may save your organization money, may save your organization time, may give you access to greater flexibility on your board, etc. So those may be of interest to you to tap into sooner rather than later. Number three, your funders may ask. It may be a sign for them of broader kind of how together is your organization. And number four, as I'll discuss, at the end of the 3-year transition period, so on October 19th, 2024, your rules will automatically be considered to have changed whether or not you actually changed your documents. So your documents will no longer reflect what your actual rules are necessarily. So that will be a very confusing situation for some organizations. To avoid that confusion, it's best to act sometime in the next 3 years. But let me give you one reason not to care about the ONCA. You should not care because you are afraid somebody will knock down your door and ask you, are you compliant with the ONCA? There are no ONCA police. The government will not come looking for you. So, engage with it because it could improve your organization, engage with it because people in your community, supporters are asking, but don't worry, the government is not knocking down your door. And I'll discuss a bit what that means in the context of the CRA, since I know most of you are charities. Okay, on to the first section. So what's new in the ONCA? I'm going to focus on 3 big things here, and then in the other the next section, I'll focus on a few of the smaller details. So firstly, I'll discuss public benefit corporations, this new concept. Secondly, financial review standards, and thirdly, Ontario Business Registry. So the registration survey tells me that most of you are registered charities. Registered charities are public benefit corporations under the ONCA. It used to be that all nonprofits, charities or not, had the same rules under the corporate statute. They may have had different rules from other sources, but under Ontario Corporations Act, they all had the same rules. Now, if you're a registered charity, if you're a public benefit corporation as a result, you face some additional rules. Now, for the few of you who are not registered charities, you may still be a public benefit corporation if you received more than $10,000 from public sources. So that might mean government, or it might just mean people who aren't connected immediately to your organization by being members or directors or officers or employees. So if you're a public benefit corporation, what does it mean for you? So there are a few additional rules you have to follow. Firstly, as I'll discuss on the next slide, you face additional stringencies when it comes to financial review. Secondly, there are limits to who you can give your property to if you dissolve, which means you end as an organization. You can only give it to government, either the federal, provincial, or municipal government, or other registered charities. And thirdly, you can't have more than 1/3 of your directors be employees. Even if they're non-voting directors, even if they're ex officio directors, no more than 1/3 of your directors can be employees of the organization. Okay, so financial review. This is definitely one of the bigger and more practical changes in the ONCA. Before I discuss the new thresholds of income and what kind of financial review you need to get, there are 2 things I want to explain. Firstly, what an extraordinary resolution is, and secondly, the difference between an audit and a review engagement. So number 1, an extraordinary resolution. So a resolution is something you pass at a members meeting or a directors meeting. In our case, we're talking about members meeting. An ordinary resolution requires 51% support in order to pass. So it could be, a motion saying we're going to change our bylaws or change our purposes or our address or what have you, right? So an ordinary resolution requires 51% support. A special resolution, so some of those big ticket items like changing your purposes require a special resolution, that requires 2/3 majority to pass, okay? An extraordinary resolution requires 80% support or more to pass. So when we talk about determining your financial review standards, the default is an audit. Every year you're required to get an audit regardless of what your annual review is. However, if you fall under certain categories, you can pass an extraordinary resolution to either get a review engagement or waive both an audit or a review engagement. So I'll discuss what those categories are in a moment, but the basic mechanism is default is you have to get an audit, and every year, if you want to get something else, you need to pass an extraordinary resolution. Okay, so what's the difference between an audit and a review engagement? So an audit, as you may know, is a public accountant comes, looks at your source documents, that means things like receipts and invoices and so on, looks at your financial policies, then looks at the financial statements that have been prepared and says, okay, based on this, I don't see any material errors. That means errors that are big enough to worry the accountant, right? I don't see any material errors. I can provide reasonable assurance that your financial statements are a reliable reflection of your financial position. That's what an audit does. A review engagement, it follows a similar process in that the public accountant looks at source documents, looks at your financial policies, looks at your financial statements. But instead of providing reasonable assurance that the financial statement is a reliable reflection of your actual financial position, instead, the accountant just says, your financial statements are plausible. I didn't see anything that raises a red flag that would cause me to doubt your financial statements. So their review engagements are faster, they're generally cheaper, but they don't provide the same assurance. So when we talk about which you may choose, you also want to ask yourself, well, what's the value that these financial review processes are giving to us, to our donors, to our community, funders, what have you? Okay, so since most of you are charities, I'll focus on the requirements for public benefit corporations. Previously, if you had annual revenue under $100,000, you could waive the audit and you wouldn't have to get anything. You would just have to prepare your financial statements in-house. That was under $100,000. Above $100,000, you had to get an audit. So that's been shifted now to above $500,000. If you have more than $500,000 in annual revenue, you have to get an audit. So the new thing for public benefit corporations is if you fall into that middle category between $100,000 and $500,000. If you fall into that category, you now have the option to pass an extraordinary resolution each year and say, we will get a review engagement instead. So that's possible. You have to look at what your governing documents say. Do your bylaws say you need to get an audit? If so, you may need to make changes to that, but you have this option now. For the few members of the audience who are not public benefit corporations, you are now never required by this act to get an audit. Always have the option of passing an extraordinary resolution and getting a review engagement. And in fact, if you have annual revenue under $500,000, you don't even need to do that. You can waive both an audit and a review engagement. So there's a lot more flexibility if you don't qualify as a public benefit corporation. The last thing I will highlight is the Ontario Business Registry. So this is one of the questions I received was, is the government making things easier to do things like change your directors and officers and so on? And the answer is yes. There's a new system online, and you can Google this. This is one of your pieces of homework if you'd like. Google Ontario Business Registry. Go to that website, and what it allows you to do is you can search corporations, and you can also do things like go into the system and change who your directors are and say when your previous directors ended and change your officers and that kind of thing. So you can make systems now directly. If you're not interested in all this tech stuff, don't worry, you still have the option of downloading forms and mailing them. You still have the option of working with a third-party provider like ONCA, for example, and having them do the online stuff. So that's still available to you. But the Ontario Business Registry gives you direct access to making some of these changes. I will, however, note that there are glitches that may take some time for the government to work out. Just for those who are kind of thinking about doing these things immediately, be aware of these glitches. One of the glitches, and this is probably the most important immediate practical takeaway from this presentation, is there's been data migration issues. So even if you have been very diligent in updating who the directors are and where your address is, I would encourage ordering a corporate profile. That's what it's called. It's basically you go into the system and you order information about your own organization. And the profile will tell you does the registry have the right information about us? Does it have our address? And I'll explain later why you need it to have the right address. Does it have the right address? Does it have the up-to-date directors? That's kind of step number one. So be aware of that glitch. That's the end of this first part. I see there's some action in the chat. So I can take your questions now.
Okay, so we've got one question from April. She's asking to clarify, so the employees who attend our board meetings do not vote, they're considered ex officio to the board. Will they count toward the new limits?
If your bylaws say that they are ex officio directors, right, so that they have seats on the board, then the answer is yes, they do count towards the limit. And a note about ex officio non-voting directors. The Act says that all directors have the duty to manage the corporation and have certain legal liabilities. It does not distinguish between voting and non-voting directors. So people sometimes join boards in a non-voting capacity without realizing that they are in fact taking on liability, the same liability as the directors who are voting. So that may be an important piece of information to share with your employees, but yes, it counts towards the limit.
And another follow-up onto that from Ben, the Charities Accounting Act in Ontario also makes it very difficult to have a staff member be a voting director. Is that correct?
That is correct. The public guardian and trustee has put a guide out called Paying Directors and Connected Persons, which I would encourage people to read. And it describes the rather specific situations under which it will be acceptable under Ontario charity law to have employees on the board. So it's not impossible, but there's that process to follow.
Okay, and just maybe one more question that we can touch on. Changing from an annual audit to a review engagement may be allowed under the legislation, but April's asking, will the audit still be required for grant applications to federal and provincial agencies? I think Catherine's been responding a bit in chat, but Benjamin, not sure if you have any thoughts on that.
Yeah, so this is why I put that disclaimer in there at the beginning, that this is not about funder expectations, this is about the law. So I expect it's going to take some time for funders to look at the act, see where the flexibilities are, decide if they think those flexibilities are appropriate from their perspective. But they're two separate things. So if your funders have those requirements, and I've spoken with some provincial funders, by the way, who are aware of this act and are actively looking into creating new flexibilities. So it's something to keep your eye on.
Okay, thank you. I think we can move on.
Great. Okay, so what steps do you actually need to take? So step one, figure out whether ONCA applies to you. So I mentioned this already briefly at the beginning, but I'll go into a bit more detail. ONCA applies to nonprofits incorporated under Ontario's Corporations Act and most special acts. A quick note here. If you feel that there is a conflict between what ONCA requires of you and some other act or regulation that you are subject to, you should know ONCA yields to that other act. So it's designed to avoid conflict completely. So you shouldn't worry about that, but you do need to make sure there's a genuine conflict and you can comply with both somehow. We received a question, does it apply to charities? And the answer is yes, if those charities are incorporated under Ontario's Corporations Act. So when we talk about charities, often we're talking about registered charities, which is a status under the Income Tax Act. The tax status of an organization is different from its corporate status. ONCA deals with the corporate aspect of the organization, not the tax aspect. So some charities are incorporated under Ontario Corporations Act, some are not. So that's what you want to look at, and the way you figure that out is by looking at your letters patent, your articles. If you don't know where those are, you can order them from the government using the Ontario Business Registry or the old form. So ONCA does not apply to Canada Not-for-Profit Corporations Act. So if you're incorporated federally, it doesn't apply to cooperatives, doesn't apply to businesses, even if they operate on a nonprofit basis. It doesn't apply if you're unincorporated unless you're interested in becoming incorporated. So let's say you figure out it does apply to you. The next step is you want to figure out when you need to act. So as I mentioned previously, ONCA took effect October 19th, 2021. Now, until October 18th, 2024, so this 3-year transition period, what happens during this 3 years? Your letters patent, your articles, and your bylaws continue to be valid. So all the rules in them are still your rules, even if they conflict with the ONCA. However, if your bylaws or your articles are silent on an issue, meaning they don't address some rule or issue that you're some situation you're facing, then now you look for the answer in the ONCA as opposed to looking for the answer in the Ontario Corporations Act. So that's what's changed during the 3-year transition period. At the end of the 3-year transition period, as I mentioned, your rules, if they conflict with the ONCA, will automatically be considered to have changed. And then your documents won't reflect what your actual legal rules are. Now, there is a caveat here. The certain rules will be allowed to continue being valid even after the 3-year mark, as long as you never change your letters patents, your articles again. Those rules are the number of directors. ONCA requires a minimum of 3 directors. If you have fewer than 3 directors, you do not have to put a higher number on the article in your articles, as long as you never change your articles again. Member classes and voting rights. So previously, if you had multiple types of members, a type of member is called a member class. If you have multiple types of members, previously you would put that information in your bylaws. Now you need to put it in your articles. However, if you don't want to do that, you don't have to, but you just can never change your articles again. Finally, if you have a dissolution clause, so this is a statement, a line in either your bylaws or your articles that says where your property will go if you ever dissolve. That is, when you ever end as an organization. If it says something that is different from what the law requires, you don't have to change it, provided you never change your articles again. So you can keep certain aspects of your structure. The takeaway, however, in all this is that to avoid confusion, transition sometime in the next 3 years. Okay, so you've decided you want to transition. What's the next step? Getting all the documents you need together. And this is always a good idea, as I alluded to at the beginning. So what documents do you need in order to transition to the ONCA? Number 1, your letters patent and any supplementary letters patent. So the letters patent was the document the government sent you when you first incorporated. Now, if you ever made changes to that letters patent and you filed, like as you were supposed to, filed with the government, they would send you a supplementary letters patent. So you take your letters patent, you take your supplementary letters patent, you combine them, and that's how you know what your actual rules are from the letters patent. So you need both of them. Your bylaws, you may refer to them as your constitution or your governing rules. This is basically just the document that sets out the rules of governance, such as who the members are, the directors, board meetings, when, where, how do they happen, etc., how much notice you give, etc. Minute books. You're legally required under ONCA to keep minutes for your board meetings, your members' meetings, the committees of your board, and the committees of your members. Those last 2 points I find nonprofits aren't always aware of. And I received a question through the registration, can you keep your minutes virtual? And yes, the answer is yes. One of the nice things about ONCA is that it clarifies and updates a lot of things. One of the things that it clarifies and updates is that you can keep your records virtually. And in fact, you can even keep them on the cloud. So the issue with the cloud is previously was that the servers aren't necessarily in Ontario, and you were required to keep your records in Ontario. Now it clarifies that unless the CRA says differently, and the CRA has not said differently, you are allowed to keep your records on the cloud, as long as they're accessible from your registered address. So that's your official address that's why you order the corporate profile, to figure out what the government thinks your address is. So as long as the documents are accessible, on a computer from there, then that's fine. You can keep your documents virtually. I also received a question about in-camera minutes. So here's the thing. Under ONCA, the only people who are entitled to access board meeting minutes or committees of the board minutes are directors and auditors or financial reviewers if they think it's necessary for their job. You are not legally obligated to give your minutes to anybody else under corporate law. Your funding agreements may say certain things, right, which you have to be mindful of. But under corporate law, you don't have to make your minutes public. So if you're discussing some confidential issue, an HR issue, a complaint issue, harassment, who knows, right? And you go in camera, okay? So ONCA has nothing to say about that, but you should know. You don't have to provide it to your members if they ask, and you should be mindful of the privacy rights of the parties involved. Practically speaking, this may mean keeping it in a separate folder. If you're doing things through Google Drive, being mindful about the permissions to that folder where the in-camera minutes go. The corporate law doesn't get into this level of detail. But what it does say is who has access as of right to those minutes. And the answer is only directors and auditors or financial reviewers. Special resolutions, these are the resolutions requiring 2/3 support that are important changes to your letters patent. So you may have passed these in a previous meeting, but then never incorporated the changes into your bylaws or letters patent. So that's why it can be important to gather the special resolutions as well. Directors and officers register. So this is a list of your directors and officers, and you're required to keep 6 years worth of records. The list includes the names of the directors and officers, their start date, their end date, if they're former directors or officers, their address, and if they've agreed to receive things digitally, then also their email address. And the same thing goes for your members register. So you're required to keep a list of your members. That includes their name, their start date, their end date, if they're former members, their address, and if they've agreed to receive things digitally, their email address. The other thing that is a bit new in the ONCA is the requirement to keep a record of director consent forms. So the question is, when does somebody become a director? It's not when they're elected, because if that was true, you could elect anybody to your board without telling them. And, that'd be a fun practical joke 2 years later, say, haha, you've been liable this whole time. That's the kind of jokes that people like me get up to. But they don't automatically become directors. You have to get in writing. I consent to be a director of X organization on such and such date. It doesn't have to be a long legalistic document. And in fact, we have some wording on our website, but it does need to be in writing, and you do need to keep a record of it. What happens if you don't have a record of it? Practically speaking, if somebody's been acting as a director for all that time, the courts will likely treat them as a director, but it's just one more thing that you don't want to have to fight if it ever comes to a dispute. I will also say that a director consent form is an opportunity to take a moment with the new director to make sure they understand what they're actually signing up for. So you can make this director consent form include a code of conduct. You can include information about the rights and duties of directors. So it's an opportunity for education. So it could just be this legalistic thing you have to do, or you could make it a meaningful moment in the onboarding process. And the last thing I'll mention for records to gather is your annual revenue. This will determine where you fall in the whole financial review requirements. So I'm going to reiterate. Make sure the government has your right address and up-to-date directors on file. I will note the address cannot be a PO box. It has to be a physical address. Okay, so we received some questions about the actual process of updating your bylaws and your articles. So I will go through the typical legal process with the disclaimer that if your bylaws suggest a different process, then you should follow that, with the exception that the final say is always with the members, the voting members. Okay, so the typical process for updating bylaws and articles goes something like this. Number one, the board approves the changes. The changes are effective as of the date that the board approves them, up until the next members' meeting. The next members' meeting, if in order to empower the members to vote on those bylaw changes that were made, notice must be given sufficiently in advance, and your bylaws may say how long in advance. That provides sufficient detail so they know what they're voting on, that they can form a reasoned opinion. Then there needs to be quorum. That's the minimum number of members to have a valid meeting. There needs to be quorum at the members' meeting, and then they vote on it. They can approve it, reject it, change it. If they don't vote, if you lose quorum or something, then the bylaws cease to have effect as of that meeting. Now, so you've made the changes at the board level, you made the changes at the members level. So you're probably wondering, okay, so what do we have to file with the government? So the answer is, I'll first talk about the bylaws, and then in a few slides, I'll talk about the articles. For the bylaws, registered charities need to file updated bylaws with the Canada Revenue Agency. And there's a relatively simple process for doing that. It's available online. You could just Google on the CRA Charities website. You can just look up file updated bylaws. You do not have to file with the provincial government. You don't have to file with the public guardian and trustee. We got a question about that. The only situation really in which the public guardian and trustee will get involved in the transition process, and they've put out an FAQ about this, is if you're changing your purposes from something that is charitable to non-charitable, then they may get involved. But otherwise, the process has been streamlined. You don't need to get the PGT involved, certainly not for updating your bylaws. So for the bylaws, that's the filing that needs to happen. I'll talk about the articles in a couple of slides. Now, the actual process, the work of reviewing your bylaws, who should do it, how to do it, the answer is it varies by organization. You may have a committee. I would, in my experience, it is useful to have more than one person doing it so that more than one person actually knows what's going on in the documents. Does it have to be a formal committee? Not necessarily. It's all up to how your organization works in practice. There are two basic ways to do it. You create totally new bylaws from scratch that are compliant with the ONCA, or you take your existing bylaws and you figure out what are the changes we need to make. If you have a ton of changes to make, the first process often makes sense. If you're pretty compliant already, but you're just making tweaks here and there, the second process is often more appropriate. Our website has tools to help you with both. Here are a few things that you may need to or want to change in your bylaws. Number one, under Ontario's Corporations Act, you were required to appoint a president and a secretary. You are no longer required to appoint those offices. You still can, but you're not required. You are, however, required to appoint a chair who has to be a member of the board of directors. So this could just be a simple change in title, like you could keep the position essentially the same, but change the title, or it could be a new position. But you have to have a chair. Number two, under Ontario Corporations Act, it talked about individuals being members of the organization, unincorporated associations being members of the organization. It did not talk about corporations being members of the corporation. Under ONCA, corporations can be members of the organization, but you have to specifically allow for it in your bylaws. So why would an organization do this? It might be a way to fundraise. It might be a way to include accountability from other organizations in the community. There are lots of reasons. Number three, if you have multiple classes of members, so firstly, you have to set out the multiple classes of members in your articles with their voting rights. That has to be specified in the articles. But your bylaws now have to spell out how to join the classes, how to end, how membership ends in those classes, and how to withdraw or transfer between classes. Catherine mentioned at the beginning that there were some changes to member rights. One of the changes to member rights is that by default, members who control 10% of the votes, so not 10% of the members who control 10% of the votes can go to the board and demand that a members meeting be called. And except in specific circumstances, the board then has to go and call a members meeting. Your bylaws can set a lower number They can't set a higher number than 10%, but they can set a lower number, which you might want to do to create greater access, more power for the members, or it might be inappropriate if you think a few members will be disruptive or something. There are trade-offs, but this is now available to you as an option. Finally, I'll highlight that members do not have the automatic right to proxy voting. What is proxy voting? Proxy voting is where one person appoints another person to attend a members meeting on their behalf and vote on their behalf. They don't have that right by a default. If you want your members to have the right to proxy voting, you have to say so in the bylaws. You can also give them the right to vote by mail-in ballot, electronically, or by phone. That's all of those are now options under ONCA, but you have to say so in your bylaws. Okay, so finally, updating and filing the articles. So what might you want to change in your articles? So number one, your purposes. So let's say you found your letters patent, you blow off the dust and you look at it, you look at the purposes and you say, what, is this really our organization? We've radically shifted. These don't reflect our purposes anymore. Or we're doing new things, or we're adding. We still do this, but we also do X, Y, Z, right? Especially if you're a registered charity. It is important that your purposes reflect your activities. So it's not that ONCA requires you to change your purposes, but while you're doing all this stuff with your governing documents, if you find that your purposes don't reflect your activities, this may be a good opportunity to say, okay, we need to update our purposes. And if you're a registered charity, this is one area where I would encourage consulting with a charity lawyer because what's charitable can be very finicky. You can also consult with the CRA. You can tell them what you're thinking about. And a tip here: when you call the hotline, you don't need to give them your name, and they don't record your name. So it's not like you have to be afraid if you ask them, you're going to get an audit or knocking on the door the next day. Another thing you might want to change. So previously, the number of directors was specified in your bylaws, and you could only say a fixed number of directors. Like our board will have 6 seats. Now, the minimum has to be 3. And you can say a range. You can say something like 5 to 9. Your default quorum, the minimum number of people required to have a directors meeting, will go according to the minimum number. So if 5 to 9, your quorum is going to be 3. But the nice thing about having a range is that, let's say a good recruitment opportunity comes up, somebody is a good prospect for the board, or one year you have a very big show, and so you need some additional capacity on the board. Having a range of directors gives you that flexibility where you can recruit additional people one year. It's not appropriate for everybody, but now it's an option. As I mentioned, member classes and voting rights have to be specified in your articles. And if you want to restrict your nonprofit's powers, prevent your nonprofit from borrowing or selling key assets or something like that, then you have to specify it in your articles. Okay, so like I said, when it comes to filing articles, you have the option of downloading forms and mailing them in. You have the option of working with a third-party provider like OnCorp. If you want to access the Ontario Business Registry, you're going to need 3 things if you want to do the filing yourself online. 1, you're going to need a company key. And the company key is a PIN number that allows whoever holds it to access and make changes to the corporate information on the registry. The way you get this number is Google Ontario Business Registry, go to that government page, scroll down a bit, and there's a form. Anybody can order your company key. However, it will be sent to your registered address. That's why it's so important to confirm that the government has the right registered address on file. You can then give your company key to your auditor or your lawyer or whoever deals with the government on your behalf, but you are going to receive it first, or at least whoever your registered address is will receive it first. Then the individual who deals with the Ontario Business Registry also needs a OneKey profile and a Services Ontario account, and that's stuff you can sign up for online. Okay, so that brings me to the end of the substantive part of the presentation. I'll take a few minutes to give you a tour, but before I do, I see there's some questions in the chat.
Yes, Lauren here. So first question is from Ada. She's asking, does a signed confidentiality form work as director consent?
The answer is it depends on the wording of the confidentiality form. If the confidentiality form includes wording such as, I agree to be a director of X organization as of X date, those are the key pieces of information, then it could. As I mentioned, the document you could get multiple birds with one stone. So a confidentiality agreement, sure, could be one way of doing it. It all depends on the wording.
Thanks, Benjamin. So next question is from Jerry. She's asking, membership of our orchestra is only the board of directors and our current bylaws. Is this still acceptable under the new rules?
Yes, so ONCA has not changed the different membership structures that are available to you. So the self-perpetuating board structure is still perfectly possible.
Okay, I think that's all the questions in the chat for now.
Great. So how CLEO can help. So I will now share my screen. So this is our website, nonprofitlaw.cleo.on.ca. And on the website, you'll find information about how to incorporate. You'll find information like more detail about a lot of the things I talked about today, rules for meetings, membership structures, the different rules for charities, directors and officers, and so on. The key thing is the steps I discussed are all here under transition to ONCA. So under update bylaws, we have a number of tools that will help you take the different approaches I mentioned. So let's start with how to adjust existing bylaws. So you go here, and at the bottom, I would read these various disclaimers. It talks about the steps you can take and how to use this tool. But you go into the tool, and there's the same more information to make sure you really read it. And it gives you a side-by-side comparison of typical provisions that you may find in your bylaws under the Ontario Corporations Act and the differences now that ONCA allows. So it kind of goes through the main sections with a good bit of detail. It also points you to the sections of the ONCA. So if you want to look at the legislation yourself and see the specific wording, then you can do so. So again, this tool is appropriate if you think you're mainly okay, but you just need to tweak things here and there. It's also a good one place to look at a lot of the differences between ONCA and the OCA. The other tool we have, so if you go to, and I'll note because somebody asked about the self-perpetuating board, we have a page here that goes through different membership structures. And it discusses the self-perpetuating membership. It discusses open membership, and it goes through some of the high-level pros and cons of different membership structures. So this isn't specific to the ONCA. Again, ONCA doesn't really change what's allowed under the Act, but it gives you some governance considerations if you're thinking about changing up your membership. The other tool I'll highlight is CLEO's Bylaw Builder. So this is an app that asks you a series of questions and spits out at the end a document that has plain language and clear design elements that we've actually user tested to improve the searchability, the speed, and the accuracy of the people using the bylaws. So, and it's the elements that we've drafted are accurate. There's lots of options for you to customize, and obviously we can't guarantee that what you've written is accurate, but it does give you, so this is what it looks like. I'm sorry about the creepy faceless person. It's an open source software, and believe me, I tried to have it removed, but what can you do? So this is it asks you a series of questions, and then it gives you information. So even, especially in the areas where you've got lots of opportunity to customize, it gives you some information about the rules and limits. And you can create a profile, and you can save your work. You can, as long as you're willing to share your password, other people can look at your draft, or you can download it and share it with the board. Unfortunately, we don't have it where you can save halfway through and then come back into the interview after you've exited. So those are the aspects of the website I wanted to show you. There's also where is it? There's a contact us form. which should be easier to find, even though I'm having trouble. There's a contact us form if you ever want to send in a question. My email address is also going to be at the end of this presentation, but feel free. We give legal information, not legal advice. The other thing I will highlight before we jump into questions is a few of the questions that were sent ahead of time that I didn't have the opportunity to discuss in the presentation. So one of them, should we have official legal counsel for our board operations and oversight of our fundraising and finances? So the answer to this question has everything to do with how complicated your finances are, what you're actually doing in your fundraising. So some types of fundraising are more regulated than others. For example, gaming, lotteries, raffles, that kind of thing. Others are pretty straightforward. If you're engaging in street canvassing, then you may need to pay attention to municipal bylaws. The CRA does have a helpful guidance on their website on the rules from their perspective of fundraising. I would say many organizations don't need to have counsel, certainly not on an ongoing basis for the fundraising they do. It may be helpful every once in a while to check in with a lawyer and to just make sure that your practices are still good. But as long as you're staying within the bounds of your what you last checked with a lawyer about, you're probably fine. The other thing I would note is that you should always feel free to reach out to the various government departments who regulate the areas you're engaged in. So for example, in the case of street canvassing or raffles under a certain amount, that's often regulated by your municipality. Feel free to reach out to your municipality and you're getting kind of free guidance as opposed to paying a lawyer to do it. What prompted the government to make this change, to bring in the ONCA? Why is it of value to our sector? So I haven't talked about the history, but there's a long history of this legislation. It was actually passed 11 years ago, and it hasn't taken effect until just now in October. A lot of people got together in 2007, seeing the changes that were on the horizon at the federal level, seeing the way the nonprofit sector was kind of regarded by the government, and they decided that it would be a very important unifying issue and a kind of coming of age issue, if you'd like, to have modern corporate legislation. So that was the reason that kind of prompted the government to do this. Why is it a value to our sector? So it clarifies a whole bunch of things. It clarifies things like online documents. It allows for ranges on the board of directors. There's more flexibility in financial review and so on. So it really comes down to the individual details, what value it offers to each individual organization. So I encourage you to look at the details, but that's what I would say about that. Will we be able to manage the transition using internal board resources, or will we need to use an outside consultant or pass changes to government through our lawyer? So on this point, I would just emphasize that it's never all or nothing. There's lots of stuff that you can do on your own before you need to take it to a lawyer or a consultant. And informing yourself is both good for the long-term compliance. Remember, it's not just about the documents, about what you're doing on a day-to-day basis. The process of updating is part of the educational process of putting it into practice day to day. So that's valuable to do whether or not you ultimately bring it to a lawyer to maybe do a last-minute review. Again, charitable purposes are something I would flag as worth going to a lawyer for, but it really depends on how complicated, how large your situation is, whether you need to go to a lawyer. And that's it for me. Unless you have further questions, there's my email address, and I'm happy to hear from you.
Benjamin, we've just got one question from Michael. He's asking, are CLEO services free to access, or is there some kind of fee?
All free. They're all free.
Awesome. Thank you. I'm going to put Catherine back up on the screen. There you are.
Okay, and I will say a few words. So, Benjamin, I doubt you'd recall this, but I remember writing a fan email to CLEO a number of years ago, when it first came to my attention that the changes were coming down and that there were resources available. And I stand by every word of that piece of fan email. The commitment to citizen education, clear language, boundaries, and a profound, I think, ethical commitment to sharing straightforward information with smart people about next steps is something that I just find incredibly inspiring. And I'm so thrilled that we're now in the zone where the things that you're talking about can be directly applied by our members as they move forward into a new ONCA world. So again, my admiration and my deep thanks to you and to the CLEO team and to the Ontario Nonprofit Network for making this available. I expect we'll want to have you back for further presentations, but this was a wonderful overview. Thank you everyone for joining us, and please do complete the participation survey. All the materials will be sent out to you. Have a wonderful Friday, and thank you so much for joining us, and thanks again to Benjamin and Cleo. Bye-bye everybody. Have a great day.